Time is of the essence. Job sites change, witnesses' memories fade, or people get to them and they tell them not to cooperate with us. My name is Fred Aranki. I'm a partner at the firm. This is a case I handled alongside my partner, Daniel O'Toole. So the case that we're talking about involved a man who was working at a construction site on a scaffold on the outside of the building for a building renovation. So he's walking on the outside of the scaffold on a wooden plank, and the plank breaks under his weight and he falls down, I want to say probably 6 feet to the ground below, and got pretty seriously injured. Pretty straightforward from a labor law 240 standpoint, because this is the kind of thing that just should not happen. A scaffold plank should not break on job sites. They should be tested by the people that are responsible for the job site, the owner and general contractor. If they were doing proper safety inspections at this job site, they would have realized that this plank was getting ready to break and would have replaced it. From a physical standpoint, our client was a pretty standard sized guy. He wasn't like a guy that, weighed like 300 pounds or anything like that. He was pretty slim. Not that the scaffold plank would be okay to break if somebody was heavier, but it's just not something that's supposed to happen on a normal construction site. So this was a case we felt very comfortable on as far as liability. We had photographs of our client on the ground that somebody had taken. We had photographs of the broken scaffold planks. The accident was immediately reported, and there was video from the building of people basically carrying him out of the building, out of that side of the building, and into a van so that they could take him to the hospital. It was a case that we felt very strongly about on liability, and we moved for summary judgment, and summary judgment was granted by the lower court. Having photographs is always very helpful. So having the photographs of the broken scaffold planks was really helpful for us, because nobody could argue that there was another reason why he fell. It was the rare instance where you have what you need right from the start, but it also takes investigation and talking to witnesses and taking depositions of the right people, getting the video that I mentioned before. All that stuff doesn't just come to you. You have to go and get it. That's something that on every case, you do the investigation right up front, you do it fast, you don't wait for anybody to give it to you, you just go and get it yourself. You hire an investigator right away, you go to the scene, you talk to coworkers, you get witness statements. These are things that we do on every case. This was a case that we got from the internet. When we have people find us off the internet, that's usually not where it ends, because if they're finding us on the internet, they're finding other law firms on the internet. So we have to make sure we're extremely responsive. As soon as that first call comes in, we jump on it. We get over to the client. If he can't come to us, we go to him or her. We show them that we're different from other people, and the minute they sign that retainer, we tell them exactly what we're going to do so they know. Time is of the essence. Job sites change, witnesses' memories fade, or people get to them and they tell them not to cooperate with us. Witnesses can leave job sites and go who knows where. Video can disappear. A lot of videos they don't get saved, they get just kind of written over after a certain number of days. Our client was Pakistani, documented, but he just didn't speak English. All he knew was work. He was a guy who just worked really hard, never had any problems before, never had any problems with his back, never had any work site accidents that would have caused him to be disabled from employment. And then this accident happened and he was a mess. He had to have multiple spinal surgeries. During his deposition, I remember the defense attorneys recognized how hurt he was and how much pain he was in, even sitting for the deposition. And I remember the attorney for the defendant was very compassionate. She literally set her stopwatch every 45 minutes to give him a break, because she knew he would either need to stand up or get up and walk around. And she said to him after a little while, she said, "You know what, I'm gonna set my timer for 45 minutes unless you need it to be sooner, or if you wanna sit longer, that's fine." And she did that for him, and it made the deposition take longer, but you know what, we got through it. It took more than one day, and it was fine, because it was important. The case settled for $4,500,000. This is somebody who is always gonna be physically compromised. The money that he got from the case would at least take away the stress of him having to worry about not being able to work and provide for his family. So taking that stress away from somebody changes their life. One thing I've noticed about clients all the time that I've been here, almost 18 years now, is that having a lawsuit is very, very stressful, and it just weighs on you in ways that we'll never completely understand because we're not going through it. But we see it all the time, and we recognize that with people, and we make sure that they know that we understand that. But it's amazing when you see somebody after their case is over, you can almost see the weight off of their shoulders. Just having that much stress on you causes you, manifests itself physically. So having that stress off of him, it was probably one of the first times I ever saw him smile, just because he knew, like, look, I know I'm always gonna have pain, but at least I'm gonna, be able to always have the treatment I need. I'll be able to live in a nice place. I'll be able to provide for my family. So if we can just do that for people, then we're doing our jobs.